Any item not mentioned in the any mention of item number 1, CRR 41 of 24.
I propose the statement.
My lord, I am appearing for the petition. Madam, this matter has been disposed of by my lord,
Yes,
but there is a mistake, my lord. I
Just take down.
submitted it.
There's an inadvertent error crept in the order dated 5th July 2024, wherein the name of the petitioner counsel has been left out. Let the name of the petitioner counsel, Miss
Rasi Seth,
Rashi
Seth,
Seth, be added in the order dated 5th of July 2024. With the above direction, let the necessary correction be carried out. Let the necessary correction be carried out.
Items may be
Sorry,
on this date.
and Mr. So and so, give your appearance. Mr. So and so, name shall also be added for the on behalf of the state.
I'm working for the state.
State, yes,
Party.
that's what I'm saying. Your name should be added for the state. Take it. Just take his name. What's your name?
Salim Mohammed.
Salim Muhammad.
Item number 2, CRR 42 of 24.
Appear for this.
my lord, similar matter.
Same word.
Same.
Item number 319 of 24.
In this matter, I am the petitioner. As per the,
I received instructions to appear for that.
Yes, Mr. Lieutenant.
that yesterday, Your Lordship was pleased to pass order. I've just prayed for dispose of the representation, Your Lordship.
Decide his representation. Half order I dictated yesterday. You were not here, so
I received instructions just now.
अच्छा वो जो लिखवाया था ऑर्डर ये रहा Learned counsel for the respondent जहाँ छोड़ा था ना उसके बाद ऐड कर देना Learned counsel for the respondent submits that he has no objection.
I don't think.
This is in deciding the representation.
I don't pass the. Usually, here my consent is not recorded without written instructions.
So you get a written instruction. This is just representation. You're not deciding his case.
Do that, madam, no difficulty. But
Learn-
don't- I not may know, just say that since affidavits are not called for, so.
That I will do.
I not may pass the order, I not be.
This is, I don't know what objection you have.
I have no objection, my lord. but
Then
Problem is that usually the difficulty is whether if it is.
I'll rephrase-
then there
I'll
will be-
rephrase it. Learned counsel for the respondent makes a concession by
My humble request, my lord, I understand what is calling from your lordship and I completely, my lord, I also understand that, my lord. But my only request is, my lord, usually, my lord, what is done here.
Mr. Bhattacharya. This is the kind of order which has been passed. If you have an objection, I'll record
No
that.
objection, my lord.
I'll record your objection.
No objection, but my lord may not say that I have said that, my lord, that.
I have to record it. I'm not going to pass an order by directing you to consider the representation.
Then, my lord, may keep it not today, I will come back with written instructions. my lord.
Get a written instruction. Not today. You are just deciding the representation. You're not giving him the money.
Not appreciate.
I can understand that a concession is made where you are giving any kind of right. You're not giving any right. You're just deciding his representation. You can reject the representation. What is the difficulty?
Just receive the brief today, so
All-
I'll speak to them.
Next,
Item number 4, the BPS 325 of 24.
Yes,
Your Lordship.
yes,
May I please, Your Lordship?
yes,
Your Lordship, this writ petitioner, he was appointed as associate professor in 2022. The appointment order I have annexed, and this appointment of the writ petitioner was extended from time to time. And now it is up to January 2025. Time is fixed.
right.
This is important. Up to January 2025, it is
His
already
contract
here.
has been extended for 6 months. till
Yes.
January 2020.
January 2025.
Right.
Now, there were certain issues with regard to his harassment. There were some problems in the department. He was badly harassed by the officers. So he made a complaint
Right.
on 25th May 2024 by way of a mail to the Lieutenant Governor, which is at page number 62. This is important, Your Lordship. That's
Let
why
us
I'm
see
showing
that.
it.
Yes. Yes,
Now, page number 62 is the complaint he made. Soon thereafter, that is within 3 days, he is receiving a show cause notice from the Deputy Secretary Law, whereby it was contended that there are complaints against you by certain doctors of the department, where they have alleged that you have been harassing them. This show cause notice is dated 29th May 2024.
where is that? Which page?
Yes, that is at page number, just a minute, Your Lordship. Page number 68.
Yes,
Now, the petitioner informs the department that this show cause notice was issued and 7 days time was given.
yes,
On the same day, the petitioner was also refrained from attending his from the department. That is page number 71. He was refrained from entering into the department. This is 71.
and even the premises.
Yes. And then the most important thing is page number 72. Same day, another notice was issued to the petitioner by the chairman of Internal Gender Harassment Complaint Committee. I'm just reading, this is important. This is to inform you that the Internal Gender Harassment Complaint Committee, ANIMS, has received complaint against you. In this regard, you are by requested and called before the committee on 30th May 2024, 12:30 p.m. on this particular day to provide statement and clarification from your side. 1 day time, 30th. 30th, he appeared and he submitted a reply, page number 73.
Yes,
I have appeared before you, the Gender Harassment Committee at 12:30 p.m. on this in OSD Chamber Administrative Block, all these things. In this context, I must mention that I am unaware of any such indulgence of gender harassment as per the POSH Act 2013, and I request the following from you to be able to respond appropriately to the complaint received. Copy of the gender harassment complaints received against me, time to submit my statement and clarification on the complaints, because no copy of the complaint was given to me. So I said, how can I reply unless and until copy of the complaint is given to me? This reply was given to me on 30th. They are giving this particular documents on 30th itself to me. This is page number 74. With reference to your request letter dated 30th May 2024, the copy of the complaint letters as received by the IIGHCC are enclosed herewith. You are directed to appear before the committee in person with your explanation on 31st. 1 day, 31st. Then next day, I appeared, gave the bunch of explanation. I disputed, denied everything, every contents. But the special fact is that, Your Lordship, the date of those complaints, the first date, that is of the director, that is 25th May, the day when I lodged the complaint before the Lieutenant Governor. 3 complaints on the same date of 24th May by 3 doctors,
Right.
1 day before, and incidents are of much longer period. It's not known why on the same day 3 doctors together wrote the complaint. These are merits of the matter, Your Lordship. I'm not going deep into all the merits at this stage. But the position is that this was given, I gave the explanation. Now, when I am denying the charges, the procedure is to be followed, Your Lordship. The procedure under the POSH Act is there, it's mentioned. Even if suppose What is the report? I don't know. After that, what happened, Your Lordship? I have been terminated from service. Actually, what happened? It was a vacation period when these things happened. So after the completion of the vacation period, on 1st July, I went to the department to join because there was no clear-cut direction that you don't come. It was said you refrain from coming. So there will be a problem. So I went to join the duty. First day did not say anything. Second day they returned to me. They noted at the bottom of the page that your joining report is written. Not only that, they gave a complaint to the police also that he is coming and joining. He stopped coming from to the department after that. My point is that then, Your Lordship, on the basis of the show cause, I immediately filed the case after because they were not allowing me to join the duty, though my term period is there. So I filed the case for a stay of that particular.
That was listed before me only.
Yes, that was listed before, Your Lordship. Soon after filing that, on the next day or just a day
Termination
after,
letter.
termination letters. My point is that, Your Lordship, when a show cause, because that termination is connected with the internal harassment committee, because in the termination letter, the reasons are mentioned. Your Lordship knows contractual employment is very simple. You terminate an employee without giving any reason, the employee does not have any case. But if you give a reason alleging misconduct, then, Your Lordship, I have bunch of judgments with me to show that even if a contractual employee is there, if term is fixed, right from the Honorable Supreme Court to this Honorable Coordinate Bench, it has been decided that unless and until opportunity of hearing is given, an opportunity of hearing doesn't mean that you will call for an explanation from me. I'm submitting the explanation and you will terminate me. It can't be done in that way. Proper memorandum of charges have to be issued. I should be allowed to examine the persons concerned who have given the complaint, and thereafter only after all these procedure only one can be terminated. This is the procedure which I have, Your Lordship. The decisions are also there in that line. My submission is that Article 311(2) has been clearly, Your Lordship, that has been ignored by the authorities, or I can say violated by the authorities. Hastily, Your Lordship, the authorities have terminated me from my service. I don't know what is the reason behind that. And Your Lordship, I can,
Yes.
streams of judgments are there. I can.
The petitioner, my lords, and this is not the first time, my lords, and years and years, my lords, is a serial harasser. I've got, my lord, I prepared a compilation, my lord.
This is not the
No,
part of the
no, 1
complaint.
second, it was, no, the suggestion was because he wrote
Not the part of the complaint.
the suggestion was because he wrote to the Lieutenant Governor, that is why
Yes.
action was taken against him. Now kindly see, my lord, I'll just show one of 2021. This is, and he's repeatedly is a threat to the women doctors, is a threat to the patients. Kindly see, my lord, this
No,
is.
But have you seen the
incorrect.
complaint which is on
Yes,
record?
yes, my lord.
Incorrect.
So it is not about any threat. He's basically
He is,
saying
my
that,
lord, physically, kindly see the, I'll come to the complaint first. Very well, I'll come to the complaint. Kindly see, my lord, the complaint was given on page 74 is the covering letter.
yes, let us see the content of the complaint.
Yes, my lord. The first complaint, my lord, will see at page 75.
Yes.
This is written by Dr. Ajay Raj. This is by a gentleman. Now he says, huh? No, this is addressed to the director. No, this is addressed to the director. I'm writing to formally lodge a strong complaint under against
Let us see the charges.
Well, it's the contractual employee. So these are
No, let us see the charges against him.
in the
You are
complaint.
saying, yes,
Yes, my lord. So I'm reading that only, my lord. I'm reading the first complaint.
yes.
Harassing faculty members. Dr. Anand Lingeshwaran has consistently targeted faculty members of the community medicines department. Unwarranted criticism, personal attack. His behavior has made it exceedingly difficult for faculty to collaborate on work front and respectful work atmosphere. Disparaging
There is no specific allegations.
That kindly have page 78.
Yes.
78, my lord, is a complaint
Yes.
addressed by a female
Yes,
faculty.
yes.
Now kindly see below unwarranted criticism and sarcasm, doctor
I've
sarcastically.
seen that also.
Yes.
Yes.
No, so
Let's
point,
read that.
yes,
Let's read that.
and he, my lord, I'll show the WhatsApp messages also.
Yes.
He has been WhatsApping a female faculty right up to 4 o'clock in the morning. 1:44 AM was the last message that he has annexed. Of course, with my opposition, I can add the further annexures, and kindly see, my lord, his state of mind, my lord. I'll just show one document, his own letter, to just demonstrate, my lord, that what is his state of mind. He says, my lord, will see page number
Yes.
86 is his clarification. Kindly have 90. Kindly have 90 for a moment.
Page 90.
Yes, my lord. Kindly have page 90.
Yes.
At page 90, my lord will file, kindly see serial number 5, late night timing of my messages. So he is messaging a female faculty after 1 o'clock, 4 o'clock, etc. Kindly see this reply.
Yes.
The reason for odd timing of the messages was that the air conditioner in the lodge that I stayed in Delhi stopped working on 16th of May and was unable to sleep well that night due to sweltering 40 degrees heat in Delhi. I had conveyed this fact to the director by WhatsApp the next morning. Being a colon cancer survivor, my health is gradually recovering and it was not easy to adapt to food and weather conditions in Delhi. Moreover, the next day on 17th May, I had clearly informed to Director Ma'am by WhatsApp that on 16th May, I was unable to sleep well at night because the AC machine in my room broke down and so he's
India-
crazy completely, my lord. He's saying that because the AC in his room was not working, so he will
Let us-
message female faculty at night.
Let us assume, Mr. Bhattacharya, that all your allegations are correct. Is he entitled to a fair opportunity or not?
And
The committee,
yes, my lord.
did you hear him out?
Yes, my lord, he was called before the committee, my lord. That notice is also, they have
Look
annexed.
at the dates, Mr. Bhattacharya, look at the dates.
No,
One day. You give a person 1 day to respond.
no, the point is, my lord, the point is slightly different, my lord. The point is, my lord, even the director.
but do you
is
give one-
present in his presence because he has entered the director's.
So you will bypass all his rights, give him 1 day to respond.
No, but if my lord looks at it as a proceeding under the POSH Act, then perhaps the complexion is different. But fact of the matter is, he's a contractual employee. The specific term in the.
Actual employee, wait for him to, be out of job in January.
No, but we kindly see the
Don't
contract.
extend his contract.
No, kindly.
You have
see
a
the-
right. He's a
Kindly see the
contractual
contract.
employee.
I am entitled to terminate his contract if I pay him 1 month's salary, which is
Do
what
that.
they're doing.
Do that. You are conducting an inquiry.
No, that is
The
one part
moment,
of it.
Mr. Bhattacharya, the moment you conduct an inquiry, you hold an inquiry, then he has a reasonable right to be heard,
My lord,
which you are not doing.
no, but it can also be treated as a contractual termination, my lord.
Do that.
That is what we have kindly
No,
seen.
sir.
We have
That's-
given him
no,
1
no.
month's salary.
No, that's not. You are conducting a full-fledged inquiry and then you're saying it's a contractual termination.
In that case,
You
my
show
lord.
me where is the contractual termination?
Yes, kindly see, no, the contract I'll show first, my lord.
No, I know the contract is
Yes,
there,
yes, my lord.
but
No,
it's
I
not a
appreciate-
contractual
I
termination.
appreciate
Mr.
the reference is
Bhattacharya.
there
That
to the
argument
POSH
is not
committee.
correct.
The reference is there in the POSH to the
It is
POSH committee. even
completely
with
to the POSH committee. The decision is taken by them on the basis of the report filed by.
My humble submission then is, my
Yes.
lord, that he has been restrained from entering because, my lord, there is a genuine threat, my lord. He comes wearing a helmet and he goes and punches outside the director's room.
He is a contractual employee. You could have.
Give him a hearing. If my lord says so, if it falls from your lordship, let him be given a hearing, but my lord, the restraint order will be enforced, my lord.
No,
My
nothing.
lord, he's a threat, my lord. He's coming outside the door of the director wearing a helmet. He's completely crazy.
Lodge a complaint.
Well, we have lodged a complaint. We have lodged a complaint with the
Police will-
police.
Putting is
The
such
police will take
aspersion
action.
against a
No, I will
doctor.
place it on
Crazy
affidavit.
and all
I
the
will
things.
file an
This
affidavit,
is
my lord.
practically a
No,
defamation.
I will file an
But it is
affidavit.
the court
My lord may
has
grant us
to
permission.
use.
My lord may grant me a permission.
What
I'll
is it?
file affidavit.
You'll file affidavit in opposition.
Yes, my lord. No, but I'm only saying, my lord.
Stay off.
No, there is a stay of termination, but my lord, he may not be permitted to enter, my
not?
lord. Let him be, he will be, my lord, he's a threat, my lord,
No,
today.
There is no question of his being a threat. He's a doctor after all.
No, my lord, he's a psychiatrist, my
The
lord.
manner in
Patients
which
have
the
complained against
presentation
him.
is made, the word you.
Patients have complained against him, my lord.
That how these people are.
Other doctors have complained against him, my lord.
You had a right not to extend his contract. You have extended his contract. You are saying there was a complaint against him in the year 2021.
No, later, continuously, I've filed
Right.
several
So
complaints.
that's what I'm
January
saying. Then why
2020.
did you extend his contract?
Because now
Why you have been
he is
extending his
physically
contract?
threatening the director of the
No,
institute,
Your
my lord.
Lordship.
There
The
is a
director is above the law.
No, I'm
The
saying
director is God.
his colleagues
Is
are
the
being
director the
threatened.
God of this?
So I appreciate what your
Please,
lordship says.
don't say that.
No,
Who is the director?
my lord. The
He's
director
not
is a
God.
lady. No, but the director herself is not safe, my lord. Then kindly appreciate
Tell
this.
her to lodge a complaint.
She has already lodged a complaint. Complaint is already lodged. I am only submitting, my lord, if your lordship it comments to your lordship, my lord. If your lordship is staying the termination and granting us permission to file affidavit,
Yes.
then, my lord, in the meantime, my lord, at least, my lord, he will be
In the
paid.
meantime,
He is entitled to his, obviously, if he's suspended, he'll be entitled to his salary. But, my lord, There is a genuine, my lord.
Nothing, you should have genuinely giving him an opportunity of hearing. You have completely failed to follow the due process.
No, he was called, my lord. He was given hearing. The notice.
Mr.
said-
Bhattacharya, look at the conduct.
Then, my lord,
Look
alternate.
at your conduct.
My lord, may then alternate.
One day.
My lord, then my humble submission is this, my lord. Then my lord may not direct affidavits. My lord may set aside the order. My lord, we will give him a hearing, and my lord will conduct the. That would be, my lord, because there is a genuine, my lord. I am not saying so irresponsibly, my lord. I appear in. I am saying so with some degree of
This
responsibility.
harassment committee has
So,
been
my-
constituted.
let-
Just a minute,
give them hearing.
just a
Give them-
minute, what?
So
Why
you
does he not-
take back all the proceedings against him.
Yes.
No, we'll give
Conduct
him
a
a
fresh
hearing.
de novo
We'll give him a-
inquiry should
That
come.
committee,
Yes,
just a
my
minute,
lord.
sir.
We'll give him a
Your
hearing, my
just
lord.
one-
Let
one
it be
minute.
from that stage.
I'll
We'll
take-
give him a hearing.
I'll take 2 seconds.
No,
It has been constituted by the complainant.
no, they want.
This committee has been constituted by the
Let this
complainant.
not be pending, my
Let
lord.
me
Give
say-
him a hearing.
I
Give
cannot
him a hearing.
in committee, not the committee which has been constituted by the
See, my lord, the
complainant.
doctors are, he's a psychiatrist, my lord. There are patients who come there, my lord. Patients
Patient-
are, he's able to manipulate, my lord.
Correct.
See, he has been working with you.
My lord,
You have been continuously extending his contract.
my lord.
Only when the new director has come,
No,
there's an issue which has been taken
there are
place.
female doctors who have complained against him. It cannot be.
We all know how these institutions work, Mr. Bhattacharya. We all know.
We will conduct,
It
my
is
lord.
not that we don't know how the institutions
My lord,
work.
my humble submission, we'll give him a hearing, my lord.
No, it's
My-
not about hearing.
No, my.
The way the committee has been
It's
set up.
Kindly see the report.
Set up
Let me place the
by
report.
the
my lord.
complainant. Complainant
You
set up
file
the committee.
everything on record.
No, my lord, let me kindly see the report, my lord. The
File
committee-
everything on record. This committee, I have no faith in the committee.
No, my lord, may
The
then.
manner in which they are proceeding is itself illegal.
Complainant itself.
One day time being given,
My
You are
lord,
treating a
I'm
doctor like
on
this?
Instructions, my lord, I'm submitting, my lord. My lord may set aside this, and my lord may direct that hearing be conducted. We conduct.
no,
hearing.
the entire committee has to go.
Yes.
The manner in which it is.
Committee has been constituted by the complainant.
Committee,
You
my-
file your reply. File your reply. Take down. In the present writ petition, the petition in the present writ petition is challenging the impugned order dated. Where's the order?
Your lordship, the order is
Page,
5th July.
112, 5th July 2024, whereby the respondent number 1, comma, terminated the contractual employment of the petitioner by invoking clause 7 of the contract agreement. It is the case of the petitioner that he was appointed as an associate professor on contract basis with the respondent number 1 on 27/4/2022. Full stop. His contract was extended from time to time. And the last extension is valid till 29/1/2025. Full stop. The petitioner alleged that the respondents were threatening and discriminating against him, and hence he filed various complaints against the officials of the respondents before various authorities. Full stop. It is alleged by the petitioner that as a counterblast, the respondent issued a show cause notice dated 29/5/2024, alleging that the management has received several complaints against the petitioner qua his misbehavior with other colleagues. Full stop. Further, via a separate order dated 29/5/2024, the respondents restrained the petitioner from entering the premises of respondent number 1 till the final decision is taken qua the complaints received against the petitioner. The internal general gender harassment committee has been, when was the committee set up?
Date, I don't know, Your Lordship. They would be able to tell the
Was-
date, I don't know. but-
Committee was already in existence.
No.
Was
It was
constituted,
already in existence.
constituted to
Members were
decide,
in vacation, so therefore it had to.
constituted to decide the complaint filed by the petitioner. Constituted to decide the complaint filed by the respondent. After the conclusion of the said inquiry, while the impugned order dated 5/7/2024, the respondent has terminated the service of the petitioner by invoking clause 7 of the contract agreement, being aggrieved by the said termination. The respondent has referred the present writ petition. Next, learned counsel for the petitioner submits that the impugned order dated 5/7/2024 passed by the respondent is stigmatic in nature and is in violation of principles of natural justice. Full stop. The counsel for the petitioner states that the petitioner was not supplied with the witness statements and no opportunity of hearing was afforded to him for cross-examining the witnesses. Full stop. Counsel further states that no personal hearing was afforded to the petitioner before passing the impugned order. Counsel for the petitioner has also drawn the attention of this court on the fact that the show cause notice was issued on 29th May 2024, and on the same day, the petitioner was refrained from entering the institution. On the same day, the petitioner was restrained from entering the institution till the decision of the competent authority. On the very next date, the petitioner was issued. There's a show cause notice, right?
Yes.
Show cause notice 29th May.
On the same day, show cause notice, the petitioner. How much time were you given?
30th, next day.
Next day. In the show cause notice, which was issued on the 29th of May 2024, the petitioner was granted a day's time to respond to the said notice
Of the internal gender harassment.
of
Committee.
the internal gender harassment committee. It is the case of the petitioner that this was discriminatory in nature, as no adequate time was given to the petitioner to respond to the said show cause notice. Full stop. Learned counsel for the petitioner further states that though she responded to the show cause notice on 30th/5/2024, but she indicated in her letter that she had not been provided with a copy of the gender harassment complaint, neither any of the statements of the complainants. Full stop. What happened after that?
After that, Your Lordship, that the
You had a-
termination.
No, my lords, kindly see
After this-
109, my lord.
Yes.
He wrote back saying that because you have not responded to my reply, I'm assuming that it is
The-
recalled.
That
Kindly see
duty-
the letter, kindly see
Sir,
the email.
Sir,
Just a
the
minute.
Kindly see his email, my lord.
email with regard to entering into the department, not with regard to
Because
any
he's
other order.
raised, he says he assumes that because he has not received a rejoinder, that means that it
Yes.
is
What
recalled.
are you showing?
Kindly see 109, my lord. He responded to the show cause notice. After
Please.
that, my lord will see 4th June he responds. Then on 30th June, he says that I hereby like to bring to your kind attention, as I have not received any reply from your end, I'll be joining my duty tomorrow. That is the 1st of July 2024. No reply from your end will be treated as deemed recall of order number 1262.
This is refraining order.
That is.
not in respect of main order.
And likewise, my lord,
Oh.
1st July also he says so.
No.
The
The report of the Internal General Harassment Committee was provided to the petitioner.
No, no, report has never
Comment-
been provided.
Or committee. Okay.
Internal-
Complaints
Was never
Complaints
given,
of- a copy
was
of the
never given
complaints
to
was not.
the,
Report was never.
was never given to him, full
Com-
stop. The
Complaint was furnished.
vice chairman, comma, the executive council is not the appointing authority and hence he cannot terminate the services of the petitioner, full stop. It has also been pointed out that no salary has been given to the petitioner for the month of
June.
No, that we are
2024.
disputing. We are disputing. We have given him the salary.
After termination, 1 month advance
Kindly
salary
see the
has been
letter,
given.
letter at 100.
I'll write, I'll dictate
Well.
your,
My lord.
for the month of June 2024, full stop. Perusal of the record. On perusal of the record, it reveals that the impugn order dated 5/7/2024 refers to the inquiry conducted by the Internal Gender Harassment Committee, however, the said inquiry report was not provided to the petitioner, full stop. The impugn order further refers to the statement of various staff members, however, neither the said statements were provided to the petitioner, nor an opportunity was given to the petitioner to cross-examine the said witnesses, full stop. Hence, after examining the record, this court is of the prima facie view that the impugn order was passed in violation of principles of natural justice, full stop. Learned counsel for the respondent seeks and is granted 4 weeks' time to file the affidavit in opposition. Reply to the same within 2 weeks thereafter. Reply, if any, to the same within 2 weeks thereafter. List after 6 weeks. In the meanwhile, the operation of the impugn order dated 5/7/2024 shall remain stayed for a period of 4 weeks or until further orders list after 6 weeks before the next available circuit bench.
Your lordship, and also the order of 29th May, your lordship,
My
1262.
lord, I am humbly
Just
requesting.
let me complete, then you can do it. Because even if this order is stayed, your lordship, that order, they will not allow me to perform my duties.
Where is that?
My
So
lord,
29th May, your
my
lordship,
lord-
just a minute, I will just refer to that, then you can argue.
Yes,
1262. Just a minute, your lordship.
page number?
Page number.
That was the first one you had challenged.
Termination order and the show cause notice I have challenged, but the just a minute, your lordship. This is page number 71. 1262.
my lord may just hear me on
These
this
two
matter.
points have to be stayed.
My humble submission is, my
Yes.
lords, even if this is a contractual, irrespective of that, even if we were to take it to the under the CCS rules, my lords, pending inquiry, I'm entitled to pass a suspension order. This is not even a suspension order. It's only requesting him not to come to the premises, my lords. He will get his salary, my lord. This doesn't mean that he won't get salary. We just, definitely, because my lord, there is a genuine, this much, my lord's leeway, my lord may grant. We are not,
The earlier order restraining the petitioner shall remain stayed. जहाँ वो लिखा है ना, the order dated 5/7 and also the earlier order dated 29th May 2024 shall remain stayed for a period of 4 weeks.
My lords may then
Orders.
only one,
Yes.
my lords, indulgence, my lords. My lords may say that this will not come in the way of any other, because if I file a police complaint, he'll produce
Learned
the High
counsel-
Court order.
Learned counsel for the respondent is at liberty. You make that concession, we'll.
No, I'm only saying, no, because this today, my lord, if he does something, police comes, he'll show the High Court's order.
You don't
he will
need a
show-
court order for.
No,
I
I'm
can't
only
preempt
submitting-
anything.
No, I'm only submitting that this will not come in. We have filed police complaints, etc. also.
The police
Now,
is at liberty.
he will say that the High Court has said that I won't be restrained from
I
coming.
don't think so. The police doesn't know what are the
Well,
powers.
some kind is necessary,
What?
my lord. Otherwise, I
What?
wouldn't.
You tell me
My
what?
lord may at least say that. This
Can
is-
I give you any preventive order?
No, I'm not saying
Then?
that. I'm only submitting that this will not, the observation or whatever the interim order that has been passed will not prejudice any other steps in accordance with law, like a police complaint.
Why should
Because
it?
my-
Why? There is no
because-
clarification.
No, because my lord,
That
if
is
I have filed a, if he's,
The
if.
police is at liberty. This is a gender
But he will
harassment
use the High
committee.
Court order to say that the High Court has said
Mr.
that I will be allowed.
Bhattacharya, how can they use this?
Some
This
clarity.
is only confined to the gender harassment committee.
My lord may say that. It is confined to the proceedings before General Harassment Committee. Only that much, my lord may say.
It goes without saying.
No, my lord may say that. My lord, it's understood. It may be my
It
lord's
goes
clear to
without
us.
saying.
My lord, it is not as clear to the parties, my lord. I am only saying, my lord, that is stating the obvious, my lord. I appreciate that. My lord may only say it is confined to the proceedings before General Harassment Committee. Only that much. That is only a fair request, my lord. That is restrained, or at least the departmental proceedings. My lords may say that it is limited to the proceedings which are challenged before your lordship. That much, my lord may say.
Mr. Bhattacharya, if I say that, then you will misuse it.
No, my lord, that is an assumption, my lord. It kindly see the other alternative, my lord. If I
It goes without saying that it is limited only to this
say
committee.
that, my lord, if my lord accepts what I'm saying, that he's wearing a helmet and coming outside the
They
door
can
of the
wear
director.
that
No,
is-
let us for a moment assume what I am saying is true. It cannot, let us for a moment, my lord, just to make my argument, my lord, kindly hear me for a moment. I am saying if what I'm saying is true,
Mr. Nag,
then-
let me hear what you want.
no, if what I'm saying is correct, my lord, that he's a person like that, then in that situation, my lord, if tomorrow police is called, he's going to
Mr.
show the
Nag,
High Court's order.
Tell me one thing. Tomorrow he goes and beats somebody. Will this order come in the way?
No, but if he is entering the premises is something else, my lord. If he
If
enters,
he enters the premises and he does something which is illegal,
then
will this order come in the way?
well, he will try to say that I have a right irrespective.
And will the
Police can't
possibility-
restrain him.
What kind of argument?
No, I'm only saying, would your lordship consider it just this much that it is?
What consideration, Mr. Bhattacharya? The cops or anybody will always be at liberty to follow the law.
My lord, that, my lord,
Why should I dictate it in the gender harassment committee? The challenge here is only to your report, nothing else. And I wish you would have carried out in a fair manner. Or you should have just terminated him in terms of the contract, given him 1 month notice and terminated. Why you had to follow all this? He's a contractual employee. Why you had to do all this? You have made your case worse. It's your fault. Why did you give him an extension?
only difficulty is my lord has.
See,
Prima facie
you
case.
yourself has done all this. It is your doing. Give him 1 month notice, he would have gone, he would have challenged it. There's nothing, it's a contractual employment. You can always remove him, terminate him after giving 1 month notice and salary for a month. Where's the difficulty? You have complicated it. So deal with it. Next.
Item number 5, WPA 327/24.
I have got the petition, permitted income.
I have not received instructions. I seek time to file my opposition.
So this is possibly the second round.
You are the only respondent here?
Third round.
Yes. Yes, please, sir.
All right. The petition, the present writ petition is challenging the impugn order dated 8/4/2024 passed by the respondent, whereby they rejected the claim of the petitioner for subsidy under the scheme inverted comma Andaman and Nicobar Island for the infrastructure subsidy for micro, small and medium enterprise 2017, right? You're only asking for the subsidy.
Yes.
Full stop. It is the case of the petitioner that the subsidy was applicable for all micro, small and medium enterprises which commenced their commercial production on or after 1/4/2017 till 31/3/2020. Full stop. The petitioner could not start their commercial production before 31/3/2020 due to the imposition of nationwide lockdown. Full stop. The commercial production of the petitioner's unit started from 3rd of June 2020. And thereafter, the petitioner applied for the subsidy under the said scheme on 16/10/2020. Full stop. Initially, the respondent rejected the said claim of the petitioner by order dated 6/8/2021. The petitioner had preferred writ petition 261 of 2021 and thereafter MAT number 08 of 2022. Full stop. This honorable court had set aside the order dated 6/8/2021 and remanded the matter back for fresh consideration. Full stop. The respondents rejected the claim of the petitioner by order dated 4/7/2023. Full stop. The petitioner again preferred with petition number 950 of 2023. Full stop. The learned single judge of this court by order dated 29/9/2023 had set aside the order dated 4/7/2023 and remanded the matter to the respondent for fresh reconsideration. Once again, by the impugned order dated 8/4/2024, the respondent have rejected the claim of the petitioner for grant of subsidy under the said scheme. Full stop. Being aggrieved by the same, the petitioner has preferred the present writ petition. Full stop. Mr. Bhattacharya, learned counsel for the.
Chakrabarti.
Oh, Mr. Chaksaw, so sorry. You should have corrected me. No, I'm so sorry. I got the name wrong.
No, that's fine.
I heard it from my brother judge.
Lordships
So,
are
Mr. Chakrabarti.
entitled to call us by any
No,
name.
no. What are you saying? Not at all. I'm so sorry. My apologies, Mr. Chakrabarti. You know, I got the name wrong when my brother judge was calling your name out. So sorry. Learned counsel, Mr. Chakrabarti seeks and is granted 4 weeks time to file his affidavit in opposition. Reply to the same, if any, within a period of 2 weeks thereafter. List this matter after 6 weeks before the next available circuit bench. And Mr. Chakrabarti, let me tell you, in the previous matter, the manner in which the authority has functioned, it is grave. I'm not saying that, the petitioner would have been very indulgent in certain ways or not indulgent in certain ways, but at least everybody deserves a fair hearing.
I appreciate.
Everybody. You can't just issue a show cause notice on 30th. Then you ask for a reply on 29th, ask for a reply on 30th. Right? Everybody gets 1 week at least.
Yes, sir.
3 days, 4 days, 1 week.
I appreciate.
Even if you're not happy with somebody, remove him. He's a contractual employee. You don't have to even follow all this. That's the only reason I have.
But my lord, I've gone to the office, my lord. There is a guard stationed outside the director's room now. It is not as if.
Tell everybody to wear a helmet till January.
You know?
Till January, everybody should wear a helmet. Next.
Item number 6, KO 10 of 24.
There, 3 times I sent to them. I could not kept 1 copy. So I pray, I request for the side to provide. List before the next available circuit. At the request of the petition, let this matter be listed before the next available circuit.
Item number 7, CRR 50 to 24.
None. The private respondent. Yes, where is he? Let this matter be listed before, at the request of the learned counsel of the petition, let this matter be listed before the next available circuit bench. Ms. Zinu for the state. You give your appearance, counsel, give your appearance. And you give your appearance for the respondent number, private respondent. Yes,
Item number 8, WPA 77 of 22.
next circuit. You don't have faith in me? List before the next available circuit bench. Give appearance. I think you had a good case. Next available circuit bench.
Item number 9, WPA 409 of 22.
Yes,
I require time to file my reply to it.
learned counsel of the petitioner seeks 2 weeks prior time to file her reply to the affidavit in opposition. Let this matter be listed before the next available circuit bench. Who appears for respondent number 7 and 8? 7 and 8? So you file your reply, you have not been. Just take down one learned counsel for the respondent. This item 9. Learned counsel for the respondent states that his affidavit in opposition is ready and the same shall be positively filed within 2 days. Ready, then 2 days, you have it in your file. Is ready and will be filed within a period of 1 week from today.
The private respondent, we have
Private-
private.
The response 7 and 8. You will file reply to the learned counsel for the petitioner. Any reply to the same, if any, shall be filed within a period of 2 weeks thereafter. You have taken so much time. Every time you have been. Next,
Item number 10, WPA 484 of 23. With WPA 485 of 23.
10 and 11 are connected. At the request of the learned counsel for the petitioner, let this.
Extension of time to filing it.
Yes, you file your affidavit. It's been such a long time. Last time also you took time. You appear for respondent number.
5. Number 5.
Even you have not filed.
Well, it's here, my lord, we don't have, well, actually, we are only, in a sense, pro forma.
I am told that my respondent is innocent.
He's asking for a pay revision.
So this is district judge,
District
judiciary,
judge.
my lord. It is actually the high court.
You'll be
judge.
filing it. Learned counsel for the respondent number 5 seeks one last opportunity to file his affidavit in opposition within a period of 4 weeks. 4 weeks, reply if any to the same within 2 weeks thereafter, list after 6 weeks before the next available circuit bench. Give your appearance.
Item number 12, WPA 1030 of 23.
This is that case.
This is that case, Miss Naad. I have put my anxious consideration to this case. See, I'm not disputing that the gentleman who has taken the child in adoption would be a genuine person. But this circle is very relevant in the interest of the child. All these children who are getting adopted. And even when I was on that side, I have done a lot of adoption matters. And we see that the protection is very eminent and very important for the children. The circular is only to the extent that it gives certain rights and makes it a legal document. Literally, it's favoring the adoptee child. So I don't see any problem in the circular at all. The adoption deed should be registered in the interest of the child.
That if your lordship is.
Because it has a very wide ramification.
Act should have been amended, your lordship.
Act, see, Hama Act, nobody touches it. Nobody touches Hama Act. But these are enabling things which actually are in the interest of the child. And that is the reason, unless until these provisions are there, it is very difficult for us to safeguard the interest of the child. Tomorrow there's a litigation. It will be so difficult that if the deed is not registered, the inheritance rights will be disputed. It is not only limited to the birth certificate. Tomorrow somebody can misuse it, take a passport, fly abroad. There's no data, there's no record. So this is something which is, I really feel in the interest of the larger interest.
I'll come to board with an appropriate proposal, your lordship.
Yes,
So that
please.
I can do the
Please.
registration part
Yes.
as well as the birth certificate.
Yes.
Because child is going to attain 1 year on 8/8.
So then it will be, then you have to follow that procedure of 33 or whatever that.
Yes, that is exactly.
Correct.
And try to bring up the proposal so that both the things can be done.
Yes.
Yes.
We can give a direction that, the adoption deed, whenever it is done, the birth certificate is done within a period of so many days, something,
It's already there, we'll place it for registration within a specified period of time.
it should be registered.
Registration will be done. So I
What do you
will come
think?
with the proposal.
Yes.
Mr. Chakravarti,
That can be done.
not Mr. Bhattacharya, Mr. Chakravarti.
In fact, section 16 of the Hama also talks about registration.
Presumption.
That is a presumption. It is not inconsistent.
Hama, there's a problem.
Yes.
There she's right.
Yes.
And I'm not disputing.
Series of judgments, of course, but I don't want to do that. Your
So
Worship.
series of judgment I can distinguish,
That's right.
that this is not something, this is entirely in the interest of the children. You can't imagine the way the inter-country adoption takes place. This is intra-country. This is a, family adoption kind of a thing or a relative adoption kind of thing. But when it comes to the larger inter-country adoptions, the kind of things which happen, you can't imagine.
Yes, I know. The trafficking. thing.
Oh, it's,
Yes, yes, yes.
if you don't have these regulations in place, it is very difficult to track a child. And even in the interest of the child, tomorrow there's a dispute, how will you prove? Your rights are also flowing out of the registration deed. You're denying those rights also. So tomorrow we'll
Yes.
come up with a proposal so
Yes.
that we can.
Yes. Right.